All right, guys, we're going to have the big conversation about the demon sleeping in the woods who has always been haunting the nightmares of crypto. We're going to talk about securities regulation. Ready? Let's go. This is something we've needed to talk about for a long time, but I think right now is the right time to talk about securities regulation in crypto for a couple of different reasons. We haven't really had to think deeply about securities regulation in crypto for the last 4 years because the US was being run by this guy, a reality TV star. But not just any kind of reality TV, it was business reality TV. He was Mr. Business Guy. That was a fundamental part of his image, pro-business. The last thing his administration was going to do was regulate business in new ways or regulate business more deeply, more thoroughly. That's not what this guy was all about. But as of January, we've got this guy. This is the guy who wants to retroactively hike the highest long-term capital gains tax from 20% to 39.6%. This is a retroactive tax hike, something the US is very much not used to. No matter what your politics, you probably have to agree this guy is a lot more about regulating the business and finance world than the last guy. We're entering a very different regulatory climate than the one we've availed ourselves of in the crypto space for the last 4 years. That's why it should come as no surprise to anybody when they see updates like this one from Sundaeswap. So in this update, Sundaeswap says some smart and honest things. They say bringing any innovative financial product to market in the US without a safe harbor is incredibly challenging, especially in the crypto space. Without legal clarity, it is very difficult to launch new products like the ISO. We understand the regulators have a legitimate role and that early fundraising platforms suffer from a lack of investor protections. We are fully committed to having a transparent, innovative, and regulatory compliant ISO and are taking the time needed to do it right. I think they're right. They're not being overly conservative here. They're exactly right. There's this gray space. There's this gray space that crypto has largely operated in. Some crypto projects have gotten punished, right? We saw EOS do what was it, like $4 billion ICO, and they were raising funds for forever. It was like the ICO that never ended, and they raised like $4 billion, right? They got fined by the SEC. The SEC found them to be non-compliant, and they got fined. I think the best approach to understanding this gray area that crypto's been operating in is to go back to the first time the SEC really entered the crypto fray, and that was with the DAO. So the DAO was one of the first gigantic projects on Ethereum. I almost invested in the DAO back in the day. I was holding a bunch of Ethereum that I had bought shortly after the ICO. And you could take your Ethereum and swap that for DAO tokens. And the DAO was going to be this kind of investor-directed venture capital fund. I think Wikipedia defined it correctly here. Basically, a bunch of people shoved 150 million by May 2016. So they shoved a bunch of Ethereum into the DAO, 150 million. In exchange, they got DAO tokens. And with those tokens, you were going to be able to vote. Curators would find projects that the DAO would invest in, and then all the DAO token holders would get to vote on which projects they funded, and then they would reap the rewards when those projects did well, right? Luckily, I did not invest in the DAO because one morning in June of 2016, everybody in crypto woke up to find out that somebody had executed a recursive call attack on the DAO, and they were siphoning off all of the assets in the DAO. So Wikipedia here says that it was around 50 million. A third of the DAO got siphoned off by the attackers. This was a huge problem. At the time, all the chatter in crypto was kind of centered, at least my perception of the chatter in crypto at that time, was that this was going to be the thing that caused the SEC to step in. And in my head, it was really difficult for me to craft an argument that those DAO tokens weren't securities. That's a problem. The SEC also thought this was a problem because in July of 2017, approximately a year later, they issued this report. This report, which laid out that those DAO tokens were in fact securities, right? But despite those being securities, the SEC report said the commission is determined not to pursue an enforcement action in this matter based on the conduct and activities known to the commission at this time. So really, I think there was just one item of conduct that caused for this to be a no action report. All DAO token holders who adopted the hard fork could exchange their DAO tokens for ETH and avoid any loss of the ETH they had invested. So Ethereum, we don't know exactly what the thought process was, right? Because we were not inside the minds of the people involved with the DAO and the other people at Ethereum. But a decision was made, to hard fork Ethereum, right? Destroy the immutability of the blockchain. Ethereum prior to all this was still going along with the premise that the blockchain was immutable, that we're not going to change what has already happened on the blockchain. This changed all that. When $50 million of investor money was lost, they were like, okay, forget about immutability. We're going to hard fork, and we're going to say that those tokens were never lost, and we're just going to give all the ETH back to the investors in the DAO. And I personally believe that is the only reason that this report resulted in no action. But the report did kind of finally lay out the SEC's vision of, what all this crypto stuff really was. So in securities law, we basically got two really important acts. We've got the 33 Act and the 34 Act. So the 33 Act is the Securities Act. The 34 Act is the Securities Exchange Act. So they're called the 33 and 34 Acts. They were passed in 1933 and 1934 when the US government realized that this whole securities issuing and trading thing was going to be a big deal. And so they created this giant framework that has just been expanded upon and ballooned since the 1930s. But we're still dealing with these acts that were crafted in the 1930s. So here we are 90 years later. Those laws and regulations are being applied to, digital currencies now. That's how old-fashioned some of this stuff is. But the courts, with case law have done what they've always done, and that's adapt these old laws to changing circumstances. So right here, the SEC is going to take us through their view of how those regulations apply to what happened with the DAO. The SEC tells us here, the registration provisions of the Securities Act contemplate that the offer or sale of securities to the public must be accompanied by the full and fair disclosure afforded by the registration with the commission. So they're saying, hey, if you're going to issue securities, the way it works in the US is that you have to register that issuance of securities with us, the SEC, so that we can make sure you provide full and fair disclosure to your investors. And that's going to include detailed information about the issuer's financial condition, the identity and background of management, and the price and amount of securities to be offered. So here's a section where they tell us straight up, DAO tokens are securities. So the way the SEC approaches this is through something that is largely referred to as the Howey test, right? And here's a little summary of the Howey test. And they're going to cite SEC v. Edwards and SEC v. W.J. Howey. An investment contract is an investment of money in a common enterprise with a reasonable expectation of profits to be derived from the entrepreneurial or managerial efforts of others. So there's 4 prongs to the Howey test here, right? An investment of money, number 1. A common enterprise, number 2. A reasonable expectation of profits, number 3, and those profits are to be derived from the entrepreneurial or managerial efforts of others. 4 prongs, right? So they're going to go through the 4 prongs. And they say, hey, investors in the DAO invested money. In determining whether an investment contract exists, the investment of money need not take the form of cash, citing a case called Uselton. In spite of Howey's reference to investment of money, it is well established that cash is not the only form of contribution or investment that will create an investment contract. So this whole line of thinking that sometimes pops up in crypto where people say like, hey, we took, Bitcoin, we took Ethereum, we took ADA. We didn't even take in any money. We're out of we passed the Howey test right there. There was no investment of money. Right here, the SEC is telling us, hey guys, an investment of money doesn't need to be fiat currency. It can be anything. They say investors in the DAO used ETH to make their investments, and DAO tokens were received in exchange for ETH. Such investment is a type of contribution of value that can create an investment contract under the Howey test, and also under SEC v. Shavers, holding that an investment of Bitcoin, a virtual currency, meets the first prong of Howey. So there you go. They've already said Bitcoin is an investment of money. So that whole argument out the window. You don't get off the hook just because you didn't take cash in exchange for your tokens. So it's a common enterprise. We need to go through the common enterprise stuff, but I think you could say if you're investing a bunch of money into a DAO and you're all hoping to make money together, it's a common enterprise. The next one that everybody tries to go to is the derived from the managerial efforts of others, right? Everybody likes to think, hey, our project is decentralized. It's a DAO. The first letter of DAO is standing for decentralized. There's nobody in charge. We're not in charge. The SEC disagreed. They said the central issue is whether the efforts made by those other than the investor are the undeniably significant ones, those essential managerial efforts which affect the failure or success of the enterprise. And there they're quoting a case called SEC v. Glenn W. Turner Enterprise. The DAO's investors relied on the managerial and entrepreneurial efforts of Slockit and its co-founders and the DAO's curators to manage the DAO and put forth project proposals that could generate profits for the DAO's investors. So, I mean, think about this for a second. Everybody who invested got to vote on which projects would be funded out of the DAO, but that wasn't enough. The part about the curators fulfilling the managerial efforts of others prong in the Howey test is pretty straightforward. I think everybody can understand that. The other part that's maybe even more important for current crypto projects to understand is the piece the SEC said about Slockit and its co-founders. The SEC said the expertise of the DAO's creators was critical in monitoring the operation of the DAO, safeguarding investor funds, and determining whether proposed contracts should be put for a vote. So a piece of that is the curation piece, but the other piece is just monitoring the operation of the DAO and safeguarding investor funds. They clarify Slockit and its co-founders did in fact actively oversee the DAO. They monitored the DAO closely and addressed issues as they arose, proposing a moratorium on all proposals until vulnerabilities in the DAO's code had been addressed, and its security expert to monitor potential attacks on the DAO had been appointed. So they're actually citing the fact that Slockit stepped in when the attacker hacked the DAO. Just them stepping in is cited by the SEC here in this section about managerial efforts. They're saying, hey, we, the SEC, are saying that investors invested this knowing that the deal was that the creators of the DAO were going to actively oversee the operations of the DAO. And that's kind of proven by the fact, the SEC is sort of implying here, that's proven by the fact that you guys did step in when it got hacked, right? I mean, isn't this exactly what investors in any crypto project today are expecting? I'm not going to name any projects, but if you think about any of these DEX projects on Cardano, how do they differ from what the SEC is describing here? I think anybody buying into any project like that today on Cardano is expecting that the people who founded the project are going to step in, they're going to monitor the situation, and if there's some big problem, some big hack, they're going to step in. That's exactly what the SEC is describing here. That's a pretty high bar. That's a difficult bar to get past, because I don't see projects. I mean, projects might have some fine print, somewhere on their website that says like, hey, we're not going to provide any managerial efforts, after the, sale of our tokens. They can say that all they want, but the SEC is going to look through, they're going to look past all that kind of language, and they're going to look at things like, were you monitoring the operation of your DEX? They're going to look at things like that, right? Were you monitoring the operation of your project? Would you guys step in if there was a problem with your project? I think it's going to be very difficult for projects to convince themselves that that's not the case. That is the end of part one. We'll continue tomorrow. Talk to you then.